Gotham Investigations, I'm Jeff Giordano. The mitigation of Mark Sievers, a crime that rocked a small town, Bonita Springs. What happens behind the scenes on a death penalty case? How do you pick a jury? What determines an individual to get convicted and sentenced to death? Stay tuned and you will get those answers. This is Gotham Investigations, and I'm your host, Jeff Giordano. We have a special guest on our show today that appears from time to time. Why do we get this individual? Because he's a prominent defense attorney in the state of Florida. Not only does he defend criminal cases, federal cases, he's also a qualified death penalty attorney. So in the Mark Sievers case, just to bring you up to speed, the prominent holistic doctor Teresa Sievers, that was murdered, a murder for hire by her husband that hired his best friend and bludgeoned her with a hammer, hitting her in the head 17 times, eventually convicted and sentenced to death. The attorney on the case, Michael Mermit, he was not a qualified death penalty attorney, so they had to have somebody sit next to him as a chair, even though he's, in my opinion, was a top-notch attorney that if I were arrested for something, I would definitely not only want Frank, I would want some of these other individuals that we work part of the defense team for. Now, this is a case where we did the mitigation on the case to try to keep him from getting the death penalty. Welcome, Francisco Marty.
Thank you, Jeffrey. I love the introduction always. Well, thank you.
Now, if somebody wanted to get you for, say, some of your, as a client, how would they get a hold of you? How would they contact you?
Well, my business is the law office of Francisco Marty. I guess that's a common attorney name for corporations. I'm located in Miami, 305-545-5282, and I've been in the same place for over 10 years, and it's in Central Miami, Coral Way and 68th Avenue.
Fantastic. So, Francisco, what qualifies a death penalty case?
Well, death penalty is different, and I like to use that terminology because that's the terminology that the Supreme Court used. Death penalty is different. So, because it is different, the Florida statute is different as it pertains to death penalty. It says that once the state attorney office gives notice that they are going to seek death if such person is to be found guilty, then everything changes. There needs to be a death penalty qualified attorney. It requires a certain amount of homicide trials. I forget the exact number, but whatever the number is, I had it. It requires a certain amount of homicide trials. It requires a certain amount of trials period, and then you get vetted by the JAC, Judicial Administrative Committee, and I think judges get involved, but there's a qualification process. There are not too many death penalty qualified JAC attorneys in Florida.
So if you are a death penalty attorney, you can't try a case without having one involved in the trial.
It is my understanding under the statute that if the state seeks death, at least one of the attorneys has to be a death qualified attorney, which I am one.
And in the state of Florida, do we have a shortage on those attorneys, or is there an abundance of these attorneys?
We most definitely do. This is what happens. It's a little more complicated than just that. What happens is that most cases where the state is seeking death, because there are cases where almost never the client hires a private attorney. They're very costly. It's very difficult to determine how much even it's going to cost. So very rarely do you see a death penalty case being tried by a private attorney. Not a private attorney, because I am a private attorney, but a private attorney that got that case privately. That's a better way of saying it. So the state always appoints an attorney. When the state appoints an attorney, I always have a long answer because it's very difficult to answer this shortly. When the state appoints an attorney, the Judicial Administrative Committee has to regulate it. And their regulation is that you have to be a death qualified attorney. They qualify you. And there's two ways they qualify you. They qualify you as a second chair attorney, which, because then I'll explain that later when you ask me that. It's two trials. Death penalty requires two different trials. And then you may be qualified as a capital death penalty. It means first chair. So I'm qualified as both. And those are the two different qualifications.
Now, do both those attorneys have to be present, the second chair and the first chair? What's the difference?
They do have to be, you have to have, under the statute, once the state gives notice, you need a four-man team or woman for individual team. You need a qualified first chair death penalty attorney. You need a qualified second chair death penalty attorney. You need a qualified private investigator like yourself, which is why you were able to sit in that case. And you need a mitigation expert by statute.
In this particular case, I was the mitigation specialist on the
Yes,
case.
you were.
And they had a separate private investigator working the case, which the mitigation part, it's so much more intriguing because you're really investigating the individual's mind and contributing factors that may have contributed him to cause this murder. And these contributing factors might get him life in prison versus the death penalty, such as like being sexually abused as a child. Maybe he was under the influence of a heavy narcotic. Maybe he's mentally retarded and he committed this acts during this. Now, it doesn't mean that you can't try this case. It just means your team has to consist of those individuals. So you can kind of have a prominent defense attorney as the main attorney as long as he has this team behind him during the trial?
Correct. I believe the statute requires at least the participation of the qualified attorneys. And by the way, I'm going to sidetrack now. I read your book. I know about the case because you sent me the material, and I'm big on mitigation. It's really what I love. I'm a first chair, a second chair, but I love the death penalty mitigation part, and you did an excellent job.
I
Excellent
appreciate
job.
that, and I appreciate your comments on the back. And
You really did.
that's the mitigation of Mark Sievers, Till Death Do Us Part. It's available on Amazon Books. Please get it. Put your comments in there after you read it, and give us your thoughts.
I read the book, and for anybody that's listening, it's death penalty is really something that people are not. They always wonder how it works, and I think reading that book gets a regular person a very good idea of the big different kind of trial called the death penalty trial.
People don't understand how much work goes into these cases. The attorney that tried this case, he actually took out loans, and it cost him like $350,000 in loans, maybe even more than that, not getting into his personal life. But the purpose was that if he was found not guilty, Mark Sievers, the defendant, would have access to all these life insurance policies, and they would be able to pay their attorney's fees. Also, they had producers following him around filming this, so it was also the advertising that he would get from this case if it was found not guilty. And then besides that, he truly believed in his client's innocence. Until this day, there's just collaborating evidence that there's no DNA, there's no direct phone communications directing him. The defendant, to his defense, still claims his innocence, even though he's sitting on death row now. How often have you seen that, where an individual gets the death penalty and there's really no direct evidence tying him in, like such as DNA? This is a case where he was actually in another state when the crime was committed, and eventually the individual that was arrested actually, to reduce his sentence, said that he was hired by the individual, his best friend, and he was hired to kill his wife. And his sentence was reduced to 25 years. The other co-defendant in the case received life in prison, and now Mark, that wasn't even there when the crime was committed, he was actually sentenced to death.
Look, Jeffrey, without going into the details of his case or any specific case, we would love to think that we live in in a system or in a society where there's no way that you could be sentenced to something like death if you didn't commit the crime. The truth is that is not true. You can. And this is in no way for those state attorneys that are listening to say that the state maliciously goes after people. No, that's not the case. The case is that sometimes evidence throws you in the wrong direction. It really does. Right now we have cell phone evidence, which is very technical. I have a case now, and I don't want to discuss it. It's still an ongoing case. But most of the cases on cell phone are very scientific evidence. And cell phone may place me and my dad, he's here listening to this program, in the same location, but it doesn't really mean that we were next to each other. So the answer to your question is, yes, you could definitely be sentenced to death and not have done it. I could think of a couple cases right now. I don't want to mention their names either, but you probably know some of their names. Miami cases, at least two of them. There were individuals that were sentenced to death. They stayed in custody for over 18 years. One of them specifically, and if he listens to his program, he's going to know I'm talking about him. 18 years in prison. Another one, about 15 to 20 years. The cases were appealed. They came back to trial court. They were found not guilty the second time around, and they're walking the streets right now. So if we believe in our system, we have to believe that these people were sentenced to death wrongfully. Now, don't confuse that with, say, well, they're innocent. No, it's not about being innocent of anything. They're innocent of the charge that they were charged with. So yes, you could definitely be found guilty, sentenced to death, and not have done it, which is one of the reasons why I am not, I don't support the death penalty, because I know that I believe in our system. We have a great system, but it's not perfect.
Gotcha. So, Frank, have you ever had a case where they were sentenced to death and they were actually put to death?
I have represented 3 death penalty clients. I haven't had a case where that has happened, because these cases have not been tried yet. And let me explain another thing that the general public is not aware of. Death penalty cases last a long time. One of my death penalty cases is a 2013 case. It hasn't been tried yet. So that's sometimes an attorney will spend a decade trying a case. So I don't have that. I have those 2 that I happen to know both defendants personally. One of them was my Marine Corps sergeant, and my Marine Corps sergeant was sentenced to death. The other individual spent a good portion of his entire life in prison, and he's out now because he was not guilty. So I have seen it. It hasn't been one of my clients.
Now, what a lot of people don't realize as well, those of you that follow us know that I was a police officer for 30 years, and normally, when you're in that police mode, you feel everyone is guilty right away. So now we're on the other side of the law. So why I'm so prominent in these cases as a mitigation specialist to get these individuals, not to get the death penalty, to get life in prison, is people don't realize that a lot of individuals, not just here, but the death penalty is in other states, that get convicted and they're on death row. Later on, with which we could talk about that after, they start getting appeals, and they have collateral attorneys that take it from there after they're sentenced, that they actually get off death row and they get put life in prison amongst general population. Everybody was all upset about the Parkland shooter, that he got the death penalty, but then he got found for life in prison. They didn't give him the death penalty. They were all upset. But there's actually been cases where people get converted from death row to general population, and they kill a guard, they kill another prisoner, because life is so much better on death row that they want to get back there to be by themselves in a cell. They don't have to worry about getting shanked. They eat differently, not in the room with 1,000 other inmates. They don't hear the crackling of the bars all night long. They respect themselves on death row. What's your experience with that?
Okay, that's a good topic. I like that topic. Now, I've never seen a death row in Rayford. I've never seen it, but everybody knows that it's a specific unit, and it's good life there apparently. But independently of that, I want to address the whole life versus death. Something interesting had happened in the last few years. I don't know, but before I was an attorney, 40 years ago, I became a corrections officer, and I worked in a unit where some of the people going to death penalty were there before they were sent. So there's a misconception about the people that are sentenced to death. A lot of individuals that are sentenced to death are requesting to do without the litigation process so they can be sentenced to death. The change that has happened a few years is that most people think, well, death is worse than like the Parkland case. The truth is that life sentence to many people, not me or you, we don't know the experience, but many people that have lived the experiences will tell you that they much rather a death sentence than a life sentence. Specifically now, before people didn't want death penalty, not because it's death, nobody wants death, but mainly because it was the electric chair. And everybody feared that moment, that last minute. Now it's not. It's a lethal injection. You go to sleep. So I invite everybody to think about it for a second. If you were sentenced to life, the rest of your life in a prison cell, and your other option is to go to sleep and never wake up, I'm almost sure most people would pick go to sleep. So what I tell those people that opine that no, this guy made away like a bandit, he got sentenced to life. Life is a horrible thing in prison. So that's my answer. My answer is the death penalty for most people that have been sentenced to it now, it's much better than a life sentence. I've met those people. I've represented them. And I can assure you that many people much rather be sentenced to death today, not when it was the electric chair, than be sentenced to life.
And I guarantee you there's even some people that did not commit a murder and are sentenced to 20, 30 years, and they would much rather be put to death than to sit behind bars for 20 years waiting for their sentence to finish. And what people don't realize also is if you are on death row, you're sitting there for at least 20, 30 years before your number's even called, because you have attorneys appealing your case even though you don't want it appealed. They're coming and they're appealing these cases. And I actually sat down with Mark when the trial was coming to a conclusion before we knew what the verdict was. And I kind of asked him that question. I says, Mark, have you ever thought of if they give you life in prison, would you rather have the death penalty? And then I kind of did a little research and I explained to him life in prison versus
right.
Life in prison on the death row until you're put to, and he goes like, gee, I never thought of that. I guess I'm going to have to maybe ask some of the guards and start researching that. So it was kind of preparing him for what could happen and eventually did happen. Can you explain to our listeners what's not only qualifies for a death penalty case, but manslaughter versus second-degree murder versus first-degree murder, and when does the state actually seek the death penalty?
Well, manslaughter is when you commit culpable negligence, you did something without intent, but somebody died. And just to give some examples that maybe everybody can relate to, New Year's Eve, shooting a firearm up to the air and somebody dying down the street, that's manslaughter. You didn't intend to kill somebody, but you did something that you should have been pretty sure somebody could die. That's manslaughter. Manslaughter is driving in a car 120 miles an hour in a school zone, and you hit two kids, and you say, well, I didn't mean to hit them. Well, that's manslaughter. You didn't mean to do it. First-degree murder, it's called a capital offense. It's premeditated. You thought about what you were going to do. Now, the Supreme Court says that it only takes a twinkle of the eye. You don't need to think about it for half an hour. The truth is that the state attorney is pretty conservative, and they want some thought process. But that's the difference. Premeditation versus it just happened. Second degree murder is you probably intended to commit the act. You shot somebody, so you know it's shooting. You intentionally committed the act that caused the death. You see, manslaughter, you committed an act that you had no idea was gonna, but you should have known. Second degree murder, you committed an act that you shot somebody, you know he could die, and he didn't die, or he died. So now first degree murder, you went over there and you were gonna kill him, and that's first degree murder. Now, when is it a death penalty and when it is not? It's up to the state. A first degree murder it could be exposed to death. Every first degree murder. The truth is that the majority of first degree murders are not exposed to death because the state chooses not to. They have a death penalty committee, and I believe that's how they do it in our jurisdiction. The committee gets the case and they decide if the act, the surrounding circumstances are so egregious that it deserves death. Because the Supreme Court, I started the program by saying the Supreme Court said that death was different. It's for the worst of the worst. So the state attorney has a meeting, I would hope, and if they decide that this act is committed by the worst of the worst, then they give the notice, we're going to seek death. But not because of the charge, because of the surrounding circumstances about the act.
Now, to a family member that experiences, obviously, another family member murdered, to them, the act can't be, the bottom line is your family member is dead. It doesn't matter if they're hammered in the head 17 times like Teresa Sievers. It doesn't matter if it was one shot to the chest and the person bleeds out and dies, rather than somebody shooting them 20 times. Death is death, which is kind of sad that that's how they look at it, because if I had a family member killed, I would want the worst for that individual that did that. Now, is there any difference when you pick a jury for a death penalty case versus a regular trial? Is there any difference in picking those jury members?
It's a completely different process. As a matter of fact, if you were to tell me what's the difference between a first-degree murder trial where they're not seeking death compared to a first-degree murder trial where they're seeking death, the only difference, or the main difference, is the jury selection. Because remember, in a jury selection, normally, you're not to speak about the sentence. As a matter of fact, it's a no-no. You can't bring up the sentence. But in the jury selection for death penalty, that's what you speak about the most, because you want to make sure that you select a jury that some jurors will tell you, I will never sentence somebody to death. Well, that's not fair for the state, because the state says that death penalty is and some other jurors will tell you, anybody that kills anybody, I'm going to sentence to death. Well, that's not fair for the defense. So the difference is, in a jury selection for death, that you do speak to the jury about the sentence, about what this individual will be sentenced to if he was found guilty. And before you ask, just in case you forget, we can't finish without doing this. The other main difference is that it's two trials. You get one trial that has nothing to do with the death penalty. It's a regular trial. Is he guilty or not guilty? After they have that verdict, then you do the second trial, where it's where you bring up the mitigation to convince the jury that he should be sentenced to life rather than death.
Now, how often do you see in a trial where they're seeking a death penalty that one of their pleas is life in prison versus death, that they offer that to the defendants?
Say it again, I'm sorry.
How often do you see in a death penalty case where the state will come around, or the feds, and offer them life in prison if they just admit guilt?
It happens. I had one. I had one. I think it was even less than life. Now I forget. I think the offer was 70 years. Doesn't sound like less, but it is. But yes, that happens. Right before, that's really the job of the second chair attorney, to try to convince the state before the trial to offer something less than death. That's what we call it in law, something less than death, right?
So when we're talking about picking the jury, you have the same jury that was at the trial, though, and they're the same jury that's at the death sentencing
Yes,
trial.
they are. Yes, they are. But in the second trial, you're going to tell them personal characteristics of the defendant and things that are written in the statute. That really the statute is very wide, very vague. No, vague is not the right terminology. It leaves room for a lot of things to come into mitigation. Practically anything that you think can convince you that this person should be sentenced to something less than death, you can use that to say, I don't want to sentence him to death. And if just one juror says, I don't want to sentence him to death, the second phase trial is over, he's sentenced to life. One juror says, I'm not going to sentence him to death. He doesn't even have to explain why.
How do you pick that jury? Like, do you get to say, I don't want this person? Does the state get to say, no, I don't want that person? Who gets the first selection? Who gets the last? How many strikes do you get on that individual that says, I wouldn't sentence anyone to death? Obviously, the state would say, you're out.
Correct. An individual like that, there's something. It's real complicated. To be honest with you, Jeffrey, the whole jury selection for death penalty. Years ago, they came up with a new system, which is the system that I believe in. It's called the Colorado jury selection method. Normally, you've seen it on TV. They ask jurors questions. Under the Colorado method, the defense attorney's main primary goal is to identify the killer, the person that's going to kill anybody, and to identify also the other one, the one that won't kill. And that's the guy you're trying to select. If you select under the Colorado method, you're trying to select one person that you feel is not going to kill this guy. And if you select them, you're done. Because remember, under the new statute, it has to be unanimous. So if I convince 1 out of 12 that he doesn't deserve death, so under the new jury selection method, it's a method. You can pick it or not. You try to, your target is trying to get one person that you feel comfortable based on the questions that he's not going to sentence this guy to death. And that's the guy, that's the jury you select. So I don't know, did I answer your question? I went off like a crazy man.
Are you yourself able to say, I don't want this guy? And is the state able to say, I don't want this guy?
Yes,
How many turns
it's
do you
called
get
preemptory challenge or cause challenge.
Okay.
A preemptory challenge is sort of like a freebie. I'm going to remove, but you got to give an explanation. Mainly the other side could say, wait, it's preemptory, meaning there's not a specific cause, but I need to explain that or prove that it's not based on race or sex or ethnic. I mean, I can't say my client is black, this guy's not black, I don't want him. Or my client is Cuban, you can't say that. But I could say, preemptory, there's not a specific cause. Now, or you get rid of him because of cause, meaning there's a cause that makes him not a good juror, he cannot be impartial. And for example, he said, I think that anybody that kills somebody has to die. That means he's not willing to follow the law. The law says that that's not what it is. So those are the examples. So it's called a cause challenge. I challenge this jury because he cannot be impartial, or a preemptory challenge. I don't want him in my jury. And it's not a race reason or an ethnic reason. It's just I don't want him.
So in this particular case of Mark Sievers, there were two co-defendants, Curtis Wayne Wright and Jimmy Rogers. People, when they watch these, TV shows and stuff like that, they think that all the evidence can just get in, the jury sees the whole picture, and then they make their decision. But that's actually not the case. In this particular case, the defense team was trying to present to the jury evidence that was found that Jimmy Rogers' girlfriends took the police to the site, which one of the officers was actually being investigated for fabricating evidence in another case. So this was a jumpsuit that he wore during the homicide and went back to his state and threw it in the grass. So the pictures of the jumpsuit were pretty much looked like they were staged because the area of grass was cut throughout, and the evidence was that interviewing people out there with the defense team that he had, his private investigator, that the grass was cut, prior to the suit being there. So the grass should have been high, particular, could have been one or the other underneath it. Right. And a judge said in that particular instance that it didn't really affect any of the police's testimonies or the witness of the witnesses, and they did not allow the jury to see the photographs of the evidence that was collected. How do you feel about that, and why wouldn't a judge, considering the death penalties on the table, not allow every evidence or every possibility for that defense team to get in?
Okay, that's the first time I heard those details, and I try to capture what you said, but in sum, that's our biggest challenge as attorneys, because defendants always tell you how they're going to prove their innocence, and they want to introduce an array of things that are not admissible. There's so many hurdles to evidence, Jeffrey. It's got to be relevant. I think the judge maybe found there that it was not relevant. Maybe he found that it was suggestive, meaning that it suggested specific culpability or not culpability. Maybe he found that it was not authentic. There's so many hurdles that you have to surpass to admit something that I don't know that specific case. I would have to look to see what that was. I know you explained it briefly, but it has to be authentic. I think you said something about the grass not being the way it was. For example, if I didn't take an actual picture of something that happened at the crime scene, but I want to give like a replica of it, well, that may not be admitted because the jury needs to see exactly the way it looked. I have a case right now, which is an attempted murder case, and there's a big discrepancy whether the gun was cocked or not. And the gun, I have a picture of the gun on the floor, and the hammer is back. Well, the hammer is back doesn't mean that it's cocked, and the hammer is back not where the gun landed right after the incident. So there are so many things that I don't know. I can't answer to that, but I can tell you that admitting something into evidence has to go through all the hurdles. Many times I've gone to trial and what I thought was my greatest piece of evidence was not admitted. And now you got a big problem. And what I thought was the worst, most damaging evidence to me by the state, but I also thought that I could argue against it being admitted, was admitted. So it's very difficult, and it's a judicial decision. Sometimes the judge admits it. It doesn't mean that he righteously admitted it, or it doesn't mean that he righteously did not admit it. If that were to be appealed, maybe the Court of Appeals finds that it should have been admitted. So this is how law is very interpretive. So that judge found, for whatever reason he found, I'm sure he stated it, that it was either suggestive, not relevant, or not authentic. I'm sure that's one of those three answers that he must have given.
Could that lead to an appeal later on, that wasn't brought in?
Correct. If the attorney feels that was an erroneous ruling, of course, he appeals to the DCA, the District Court of Appeals, that rules that jurisdiction, and sometimes they get reversed.
Because we see that often when we do private investigation work for defense teams, especially in these smaller towns. Not, our show here is in Miami area, which is pretty large metropolitan city. But when I have these cases in smaller towns like Bratton Beach and other locations, is I find this more and more that the judge doesn't allow, evidence in, especially involving police officers. One was a battery on a police officer case where, we found from previous police departments racial statements that he was sustained on, beatings that this officer did, and the judge says, no, we're not going there with it, and they just don't allow it in. So if the jury were to hear the character of this officer, their outcome of the case may have been different, and we're hoping to get a show just on that case particular. But, what have you seen related to that type of thing where the judge doesn't allow an officer's character to be brought in with IA complaints and such?
Well, character evidence, that's an entire chapter in evidence. Character evidence is a monster. Character evidence per se is not admitted. There are reasons for which it could be admitted, and that's impeachment and stuff like that. You have to fall under some of those exceptions. I'm not sure the example you gave, and I'm not sure of the exceptions right now. But character evidence is a biggie. For example, in a defendant, character evidence is not admissible unless you feel you fall under some of the exceptions. On a victim, character evidence is not admissible unless, for example, I had a self-defense case where character evidence, I had to argue for 2 days for character evidence of the victim to be admissible, character evidence of his violence, to show that my defendant acted in the right way. Now, character evidence of a police officer to impeach him, which is, I think, what's trying to happen here. He is lying because in the past he did A, B, or C, right? That's
Correct.
what's happening
Yes.
here. Right. The judge may have found that the A, B, and C that you brought up does not specifically impeach him. Maybe if he said, I hate Cubans, doesn't necessarily mean that he's lying tomorrow in the stands. That's a discretionary call from the judge. Perhaps, maybe character evidence of something he did in the past, like lied in a previous arrest affidavit, maybe the judge would allow that. A racial statement made in the past to show that today he's not credible or he's impartial, that's a very iffy area there. The judge may not find that qualifies under that window for impeachment.
So there's
sometimes I feel that my answers are not straight, but that's how we argue in a courtroom. And some people sit in a courtroom and they come out, and you come out and they ask you what happened, because this is what happens.
And I'm sure you had the same judge on another case that you go back in front of him, and now he allows that evidence in, and you're putting your hands on your head saying, the last case he didn't even
Absolutely. It happens all the time. Judge A will allow this, Judge B won't. Or you win this case in front of trial A. If you were to try the same case with the same evidence on a different day in front of a different jury, you get a different verdict. Absolutely. That's why trial is risky business.
Now there is that's a good commercial for you. Trial is risky business.
Trial is risky business.
There's a word I'm looking for, and I know it from the back of my head there, and the scotch is kind of clouding my mind. The state themselves, client is arrested of rape. He was arrested for rape previously because it was a related crime. What is the name of that? Where
evidence
the state
of other crimes in the federal system
they bring it in.
Is 404B.
Okay.
In the statute, state statute, I don't know, it's 404. I don't remember the number, but it's called 404. It's evidence of other crimes. It falls under character evidence. It means that you shouldn't believe me, or you shouldn't think that I did something based on something that I did in the past. You should think that I did something based on the evidence. And I'm telling you layperson explanation for the people who are listening to this. So what that means is evidence of other crimes is sometimes admissible.
And what is the word
to
for
show
that?
that today you acted consistent to your past, and there are certain things you have to prove. You have to prove that, not only, let's say for rape, I want to prove that he raped somebody else 10 years ago. Wait a minute. That's character evidence. Well, then you have to argue, this is an example. And I like this program because we're talking like if we were in our living room. So an example is, he raped this person in a specific manner, that it is so specific that there is an absence of mistake. It cannot be a mistake that he raped this person today because he raped this other person in such a similar way 10 years ago. You see, There has to be a
Correct.
specific finding.
It's kind of like a
what-
signature.
It is a signature, correct. And there are other exceptions, but there has to be an exception. It just doesn't come in. This guy's a thief. He took my chain today because he's taken before. That's not enough.
Now we handle a lot of cases where the clients, I believe the Sixth Amendment, that they can represent themselves, and we see this a lot, not in the Miami area, but mostly in Gavel County, which is I believe the 4th district of the state of Florida. And what's happening there, it seems that they're taking advantage of these individuals, but the defense is kind of like in bed with the state, and they're not really willing to take these things to trial. So they're kind of forcing these guys to take a plea deal, and they're like, the hell with that, I'm innocent, I'm going to trial. Have you seen a lot of that where they back out of, I'm not talking about you, but like the regular public defender's office?
I don't see a lot of that in Miami-Dade. I've seen it. I've seen individuals trying to represent themselves. They have to have a hearing. I forget the name of the hearing now. I forget the name of it. There's a name to it.
Correct.
The name of a case. I want to say it's Ferrara, but I'm not sure.
Okay.
But there are some, no. The answer is I don't see a lot of it in Miami-Dade. It does happen where client's not happy with the attorney. He's gone through 5 attorneys, and he says, I'm going to represent myself. It happens. I think you're right. I've heard of specific regions where it happens more often. I don't think we are one of those.
Correct. Now in the 4th district, because we have a lot of clients that call us from Jacksonville, Duval County, and we represent them. I mean, some of them are quite impressive because they spend their time in, they have like a law room. They file their own motions. And when you read some of them, the majority of them get struck down by the judge right away. But some of them actually have, meat to them. One of our clients that was accused of rape out there, we were able to find that the victim, which was a special, retarded, girl, actually had the same accusations against the uncle in Wisconsin. And we were able to pull those reports, and it's kind of what we were talking about, how the state could put that in with a signature. He was able to do a reverse, and there's a name for it right now. I can't think of it. But when the state got that, they kind of offered him like a plea deal because I guess the judge was going to allow it in because it was so similar of what she was accusing him of and the way he did it, where we had other witnesses when he gave a deposition. Of course, myself not being an attorney, I can't speak or anything, but the state allowed me to coach him, privately on the side. And then we had like cues, and they allowed a back room for us to go. And this individual that worked in the center, it was kind of like a open center, kind of like a YMCA environment, but it's like for drug rehabs, where the lady that was in charge says this could have never happened this way because it's pretty much a fishbowl. Everyone could see everyone that's in there. So we were able to find evidence in another state that she made these same exact claims, the same exact way to somebody else, and they ended up offering him a plea deal.
That's good work by the defense attorney. That's what a defense attorney is supposed to do. I'm sure what happened is he communicated to the state, told them, look, I'm going to bring your victim in, and I'm going to question her about previous similar accusations that turned out to be false. And yeah, that's how you motivate the state to negotiate. That may have been admissible. It's funny that you say that. I had a case in Dade County years ago where I represented somebody before he was arrested. He was being accused by his I think it was his stepdaughter. Then after that, he got arrested based on a testimony. When it was in the pre-file stage, the prosecutor didn't believe the witness, and they dropped the charges. And about 3 years later, I found out that the detective that investigated that case arrested the victim because she made a very similar accusation 4 years later on her new stepfather. And it was good to hear, not that it's good to have anybody arrested, but it was good to hear because to think that somebody would make a false accusation on such a serious charge, it's scary. So this detective realized, I guess, I don't know how the case came to him, but something caught his attention, and he said, wait a minute. This victim made a similar accusation. He investigated the victim. He saw that there was Facebook, social media, where she confessed to a friend, I'm going to screw up this new boyfriend of my mom. And he arrested the victim. So yes, I think that's very good work by the defense. I think that's what a defense attorney is supposed to do, investigate the witnesses that are going to testify against their defendant. And that was good work. Yes,
So,
that could happen.
Frank, just to let you know, on the case I'm talking about, he was representing himself, which the Constitution allows him to represent himself. So he didn't have an attorney. I was actually the one calling the state, and the state would even call me on certain days.
Well, then you're the hero. Then you did the great job.
And I would tell him, and I would have to be very careful, and I would say, I'm not the attorney, as you well aware of it, because they call me like almost every other day. Well, how about this? And I says, I'm not going to call the guy and offer him a plea. You need to do that because I'm not an attorney. But if I'm telling him to have me take the stand, and this is what I'm going to say about the victim, this is what I'm going to say being an investigator, this is what I found, and this is the evidence that we have. Because one of the reasons they don't treat those guys fairly there. I even sent a letter to the captain of the jail, and they weren't allowing me attorney-client privilege when he's his own attorney. So all the phone calls were being recorded, and they denied that in writing back to me, saying these guys know what they're in for when they represent themselves. And I kind of explained to him, he is his own attorney by the Constitution. You have to give me that attorney-client privilege. I can't be flying out to Jacksonville every day. I mean, we do these cases because they don't have money, and we get paid by the state. But they denied that. And I asked him, because there was a couple investigators who says, no, I was using this girl, and this one used that, and this one used this guy. And the majority of them got thrown out of the JAC, which is the Justice Administration System,
Administration Committee,
because they would get the private investigators and say, you're practicing law, you're out. So when he told me that, the defendant, I was very cautious when I would talk to him on the phone, and I was also very cautious when the state would call me and say, look, we want to do this, we want to do that. And I'll say, well, why are you telling me that? I'm a private investigator. I think that they kind of like try to actually hook you to get you thrown out of the system if you're doing a good job, because the last thing they want is challenges, especially by an individual that's representing himself to win at trials, because if the word gets out at that, they're doomed. And there has been articles in Jacksonville, DeVal County, of how they're treating black individuals out there, and how the state was kind of in bed with the police department. And like I said, you see this in some of the smaller cities, not major cities like Miami.
Well, you did a good job there. At first, I thought it was an attorney. You did a very good job. That guy owes you, because that's how you work a case. You work it. And yeah, I think there's a little negative tone to individuals representing themselves. I think the system sort of dismisses them. This guy's crazy.
Absolutely, there is.
I think that our judges, we have good judges. Judges, they may think that privately, but I think they read their emotions and they listen. But yes, do they take a defendant that is representing himself seriously? They should. Do they really do? I want to say that everybody's guilty of perhaps dismissing the guy and not paying that much attention, and maybe dismissing them as valid. Yeah, it happens. I mean, that's a system.
Now, in the same area, the fourth
sometimes,
district,
by the way, sometimes, and I don't know this part too much, but I'll throw it out there. Sometimes I've seen a defendant represent himself, but a judge not be too comfortable with his ability, so he has assigned an attorney to just sit next to him, unless if he needs him.
And some of the judges out there even demand that they get somebody to represent them, and they assign somebody.
Correct.
Just to give you an example, I had another client from out there that I ended up dropping the case, and I called the state. He was actually facing the death penalty. He stabbed this individual like 14 times. the witness was his daughter that was going to testify against him. He was actually admitted to what he did, and he's representing himself, and now he's saying, I'm not guilty. And I kind of, after a while, as I started looking into the case, I called the state and I says, I don't think this guy I don't think he's capable and competent to represent himself.
Right.
And I don't want to be responsible for being part of his defense team because, I'm not going to look like a ding-a-ling at the end, and I don't want to be, have that on my conscience that he's sentenced to death and he's not competent because I'm not an attorney. I can't speak on his behalf. So I said, I'm out. I told him, and I told the state, look at this guy's mind because he's not capable of doing this.
Yeah, in those cases, when somebody, it could be the private investigator, the attorney, a family member, when anybody brings the issue of competency to the judge, I'm sure it happened in that case, what the judge normally does is that they court order a psychological evaluation to test them for competency. I'm sure that may have happened there.
Absolutely. So some of our viewers out there, policemen knock on the door. Maybe they shoot somebody and it's a stand your ground case and they think it's like the perfect self-defense. Do you recommend that person just, giving the interview with the police, even though they think bank robbery, the guy came in with a gun, now you go ahead and shoot this guy. Oh, yes, this is what happened. I defended myself. What do you recommend for somebody like that that's actually out there defending himself? He shoots somebody. What should he do in that case?
Police, first thing I'll tell them is police officers go by what they see. A self-defense case, it's a self-defense case because you believed that you were in danger. So there's no way that a police officer can come to a scene and evaluate what you believed. It requires more work than that. So my answer is, whenever you have a case of violence, homicide, hopefully not, and you could possibly be a defendant, do not assume that you're going to speak to the officer and convince him that it was self-defense. Self-defense means that you believed. How is he going to make that determination? So my answer is no, you can't. Whenever you have a serious injury and you are a possible defendant, you just have to practice this. It doesn't come natural, because when these things happen, you're excited. Your adrenaline is up. You have to just think about this moment that we're having and just say, look, I need an attorney. I need an attorney. And those things could be resolved later. But it's very difficult to prove to a police officer on the scene that it was self-defense. You got an injured person. Remember, self-defense is an affirmative defense. It means that you committed the act that caused the damage. So that's the evidence. You stabbed him. I stabbed him because I thought he was going to kill me. Well, you're not going to prove that in a 5-minute interview with a police officer. I assure you of that. So the answer is you can't speak to that police officer. Again, the 3 C's that I said before. Calm, collected, and courteously, you tell the officer, look, my adrenaline is going. This is incredible what's happening. I need an attorney. Because it's very difficult to prove to a police officer self-defense to the extent that you need to prove it for him to not arrest you. It's very difficult when you have an injured person or dead.
So getting back to Mark Sievers, the death penalty case, actually the individual that found his body was another doctor. From the beginning, he was looked at as being a possible suspect, but then he was ruled out. Being a doctor, on his testimony, he comes out and he says that he checked her vitals for signs of life. Clearly, he's a doctor that can see that this individual is deceased. To me, it was an excuse of why his DNA was on the body, even though Mark Sievers admits that he called him to go see if she's okay and go in there. But his wife was actually an attorney with the state, and since he's been sentenced to death, one of the appeals that one of the attorneys made, one of the collateral attorneys now that's trying to get him off of death row, was that his testimony was he didn't know Mark close enough on why he would call him to go see if she's okay. So the wife is actually an attorney with the state, and she pretty much is connected with death penalty attorneys. So I kind of feel that the judge agreed with the defense team. That I looked at the defense team as they were kind of playing this for appeals rather than playing it to win. We don't know if this individual was also part of the swinging scene, but there was a letter from his wife that it's actually in my book, and they based the appeal on that letter, saying that in the letter they really knew Mark Sievers and Teresa Sievers very closely and intimately. Why wasn't this letter brought in before? They claim they found it after the trial, but I assure you that this letter was brought to our attention by a family member while it was going on. And I showed this letter to Mark in jail. Throughout the whole trial, he showed no emotion. He never cried. And that was part of the problem the jury had, that he didn't show any emotions. So for the first time when he read this letter, he started crying. I only let him get to about the second paragraph. I took the letter away. I brought it to the defense team, and I said, we got to have him read this letter. They didn't allow it. It got to the mitigation part. Then I says, we got to let him read this at mitigation, so they see that this lady had connection with him, but also they could see the emotions because he's going to break up and he's going to start crying. It never got in, and then later on, this letter was brought in for an appeal, saying that it was just presented by a family member. And they lost the appeal already, so he's still on death row.
The appellate court affirmed the conviction.
Correct.
In other words,
yes.
they did not accept.
They did not.
Right.
Yeah, correct.
I'm sure the appeal was an evidentiary challenge, saying that the district judge erroneously excluded the letter. I mean, I don't know enough. It looks a letter off the bat is hearsay, unless a person comes to testify. So I'm sure that I don't know the details enough to know why. I know what you're getting at.
So do you
what you're thinking as an investigator is, wow, they didn't see any emotions, which may be the reason why they deliberated the way they did. Had he read the letter, they would have seen emotions. You know,
Do you think it's a possibility?
That's how it is in every trial, Jeffrey. You're always thinking, what if,
So in the what if you add, we always add the what if factor, and that's
what if.
That's what we try to do in a jury's mind. We give them the what if factor. They have their deer headlights on, deer in the headlights, and they have conviction. But now we come in and we say, what if this were to happen? What if he was not murdered by this individual? He was murdered by another. So if we add the what if in this case, do you think that the judge, maybe you experienced something like this, could have told the defense team, we're not bringing this lady in. She's an attorney for the state or the federal government. She has death penalty connections, with attorneys that do death penalty cases. We're not going there because it's going to throw the trial to the, out the door on being the wife of the individual that found the body. And the defense team, do you see maybe agreeing, okay, we're not going to throw her under the bus, so let's go on with the trial as it is. But if there's a conviction, we're going to hold this and we're going to bring this out in front of everybody. Do you think that's a possibility?
You mean if there's a conviction, bringing that in on the second phase?
Correct, yeah. And you think the judge could say, we're not going there. You're not bringing her in as a witness. We're not going to make this
What
a fiasco.
happened? Because I missed it. What actually happened in the trial? They brought her in?
They never brought her in, and they never brought the letter in. And the claims were a family member presented this letter after the trial, when in reality, we knew this letter existed from the beginning.
It's a tough question, Jeffrey. Look how tough it is. It's so tough that a judge ruled in one way. It went to the appellate court, right? Look at so for me to give you a 1 minute answer based on what you just told, it's almost impossible. I'm almost going to pass on that question because it's a tough one.
So do you think the judge could have conspired with the defense team on, you're not bringing her in as a witness, so don't even bring that up?
No, I don't think. Do I think those things happen in today's time? No. My answer, no. I don't think. It may be different than what you think, but no. My answer is, I get that all the time. The attorney is in with the state, or is in with the judge is in with the state, or the judge is in with the defense. I mean, is that possible? Everything is possible. Do I think that in the times that we're living today, that really happens? No. I think the judges are overall professional. I think that legal decisions done like that are very difficult. I think for people that are not attorneys, it's very difficult to understand these rulings. It's very difficult. I've argued something that I believed in, and driving in my car home half an hour later, I haven't agreed with my own argument.
Well, I mean,
that's the truth.
I'm
That's the truth. And I'm sure that there's judges out there that won't admit it, that they've ruled in a certain way, and driving home they say, crap, that wasn't a good ruling. I mean, of course.
So I'm going to give you an example of kind of going against what you said there. But I was hired privately as an expert witness on another separate case, aggravated battery on a police officer type of thing. Expert witness. And with the defense team, I get all this information, and I'm picking apart the arrest left and right, and even that the police did not have probability to even go on the property type of thing. Expert witness hired privately. These small cities, they got to go in front of these judges again. They don't want to piss them off type of thing. And they also have pressure from the city, because if the individual is found not guilty, you got a civil suit. Yeah. So while I'm up there on the stand, they call me up as the expert witness. They ask me my name. They ask me my background. I let them all of my background experience from the City of Miami Police Department type of thing.
Before you tell me, they didn't let you in as an expert.
I'm not getting there yet. So the judge says, I want a sidebar right now, when I said my experience and stuff like that. Obviously, coming from Miami, the experience that we have, I was involved in 2 personal shootouts myself. I was a hostage negotiator for 10 years. I was the spokesperson for the police department under Chief John F. Timoney. The experience that we have is far greater than these small cities type of thing. So as soon as I say my experience, my name, the judge says, I want a sidebar right now. The defendant didn't go up there. I hear the judge, because I'm sitting right up there on the thing, saying, I don't like this guy. I don't like where this is going. The defense attorney goes back and says, no further questions. And I'm like, what? What the hell just happened here? What do you think happened
He agreed with the judge, maybe. Maybe he doesn't agree that the judge is right. There's so many things that factor in.
But an expert witness
I'm
is
going to
just
tell you
an opinion.
I could have a motion that I believe that is a completely viable, winnable motion. But maybe the motion is not dispositive. It's winnable, but it's not going to get rid of the case. But the judge, it doesn't like the motion, and I may agree not to withdraw the motion. It's a strategy thing, because maybe the damage of pissing off the judge or creating a relationship problem with the prosecutor is more damaging than bring you in as an expert. Maybe I thought that bringing you in as an expert was important, but I don't think that your testimony was going to be pivoting. It was going to pivot the verdict. And here I am in a pissing war with the judge in a sidebar for something that I think is important, but I don't think it's that important. So I choose to let it go. That happens all the time. I have a great motion. You're my attorney. Why don't you file this motion? Because it's going to cause too much ruckus, and it's not going to make a difference. So I think there's a little bit of that going on. He goes sidebar. The judge is saying, I don't like it. He's got a trial ahead of him. He's got many more obstacles. Even though you think, because you're the witness, that this is a smoking gun, he thinks that it's important, but it's not the smoking gun, and he's just going to let it go. It's a strategy thing.
This particular
no different
case,
than a witness says something that is completely inadmissible, but you decide not to object. Why would you do that? Because I don't want to piss off the jury. Because the jury is pissed off of me getting up every 5 minutes and interrupting them. And it's not that important to interrupt them right now. So it's things like that that I can't get into that attorney's shoes right now.
But this particular case, I was pretty much the
Maybe
last.
he made a mistake.
The
Maybe
last
you're
witness
right.
they were presenting, he had two attorneys at the end representing him. And I even asked the attorney afterwards, I go, what happened? He says, the judge says we're not going to go there. We're not going to start talking about, comparing
You know what he
officers.
did? He knew
And
that
throwing them
no
under the
matter
bus.
how great it was, she was going to deny it. He knew there's nothing that I'm going to be able to say up there that she's going to allow him to testify. So you know what I'm going to do? I'm going to let it go because I'm going to lose anyway. So I think that's what he did.
But expert witnesses are called all the time, and it's just an
But this
opinion.
judge told him
that
he's
they
not
give.
going to allow it. You can get mad all day long. You can get upset. It's wrong. But maybe he judged in that minute, just like when you're a police officer, pull the gun, don't pull the gun. I should have pulled it. I shouldn't have pulled it. He at that specific moment, that attorney said, this judge is not going to let him testify.
But
so
this-
I either go up there and piss her off for another hour and really get her really pissed off, which I know that no matter how legal arguments I make, she's not going to admit him. She's not going to allow his testimony, or I just go with her. And he went with I just go with her. That's what I think happened. I'm not saying it's right or wrong. I'm saying that that's what I think happened.
This particular case, the individual was found guilty. But you know as well as I do, let the state object. Once the jury hears something, scratch that. They're
Of
not going to
course,
scratch it.
of
You
course.
freaking hear it.
They heard it.
And that happens all the time.
Right.
And that sometimes is a defense strategy. We're going to ask this. You know yourself it's going to be objected by the
Objected, and
state.
you throw it in
But
there.
you get it in there. Have you seen that? Have you dealt with that a
All the
lot?
time. All the time. And the state does it and the defense does it.
Correct.
There's nobody can admit they
It's
don't
just
do
part
that.
of the-
They
part of
know
the
that
game.
that is you're going to introduce something that it's iffy. It's a really a fine line, but you're going to introduce it, and the judge is going to object. The state is going to object. You know the judge is going to agree, but you want to get it out there anyway. It happens all the time on both sides. It happens with the state, and it happens with the defense. And just like every attorney has their strategy. Some attorneys feel that if you got to do it by the book, that if this witness is going to testify to something that is you should object. Some attorneys feel like, and I'll say that I'm one of those, that objecting too many times pisses off the jury. So you got to pick one of the two. Well, what a bad attorney, man. He allowed this. It's just inadmissible. Well, man, you got a not guilty verdict. And I've interviewed juries many times after the trial, and they're all pissed off at the prosecutor because he kept objecting. He objected lawfully, but they don't know that. So what I'm saying, Jeffrey, that there's a lot of things that happen in a trial that has nothing to do with the law. It's just strategy, it's style, it's this.
So, Gotham Investigations, a true crime podcast. We're talking about actual cases. Like you said, this is kind of like we're on the couch debating. It's kind of like a debate. We're throwing some things back and forth at each other. So other than us, do you have any TV shows that you enjoy that you say, this is the real deal? Because what turns me off is when I start getting into these shows or even police shows, and all of a sudden then it starts, the reality is like, that could never freaking happen. That will never happen in a court of law. Do you have any shows that you particularly like yourself?
I'm embarrassed. I hardly watch TV.
Like me.
I've seen little parts of episodes that I've thought were very good. I can't remember the name of it now. I think through the years they're getting a little better. I'm trying to think of, I can't think of one right now. Can't think of him. I think they're getting better. The little bits that I've seen, I think that they're getting a little more realistic than they used to be before. I can't pinpoint any episode or any show that I can think of right now.
I did actually watch one because they were like, oh, you got to see this show, and it turned out to be a chick flick, The Lincoln Lawyer. As I got into it, I'm like, this will never happen. That will never happen. This is ridiculous. And then my wife is like sitting there, well, yeah, I can't watch TV with you type of thing. And I'm sure you go through the same thing where I just like lose interest after a while, especially in police shows, Because I'm like, that's not going to happen. You're not going to shoot somebody and then you're right back out on the street 2 hours later. Different things like
Right.
that. It's just.
I've had people recommend it to me. I don't know if I don't think I saw it. Maybe I began seeing it, but I've had like people that know that I'm an attorney and they recommend that to me.
Make your wife happy. Sit there and watch some of this nonsense
All right.
shows with her. Sometimes I'm tortured myself and forced to do these things. I've learned to keep my mouth shut and save my debate for times like this with people that are in the field. And that's some of the things that we're going to get into also in the future, just so our viewers know, is critiquing some of these police and legal shows as being part of the defense team, and would this stuff actually happen, and how these cases would go. Marty, we're certainly glad that you were able to give some perspective on the death penalty. And, unfortunately, some of your cases, some of my mitigation cases, at the end, it turns out to be a watch party.
Yeah.
Where you're, very sad, but you're sitting there and you kind of feel that. And what I wanted to tell the jury as a mitigation specialist, and the attorney is like, I'll get disbarred if you say something like that, was you're a jury and you're sentencing this individual to death. Isn't it the same thing that Mark Sievers did? Sentence his wife to death through another individual. Yeah. Now you have the power to say, I want this person dead. There's one state still has the firing squad that has the death penalty. Yeah. I forget which state that was, but I wanted to present that as well, saying what they do and how they do that is they'll have a firing squad. Everybody will have blanks in their gun, and it's all headshots, but that one individual has the round in the chamber. So when you have a jury, that one individual with the round in the chamber is each one of those juries that says this individual's guilty. Because that one round, if it turns into being a blank, as you said, it only takes one juror to say, I don't want the death penalty, and it's off the table.
It's gone.
Type of thing. So, as I said, I was like, in my head, being a police officer, saying, well, how can you not be able to come in front of a jury and say, listen, you're doing the same thing that you're trying to put this man to death is. You're giving a life sentence of death to this individual.
Correct.
I felt in this particular case, regardless if I thought he was guilty or not guilty, the children in the case, which actually that was one of the cards that we found, where you'll see it in the book. She writes to the father and says, Dad, I hear they want to put you to death. Could this happen to you? The same thing that happened to Mummy. You have two small children, 11, 5 years old. They just experienced a death with the mother. They don't understand what's going on. They're sitting there in trial, and it's Christmas time. And now your father is sentenced to death? I mean, is that fair for the children? I think that the children should have the right to visit their father in prison and decide for themselves, did Daddy do this? Should he get the death penalty? So the death penalty is as you mentioned, a horrific thing to look at. It's just a terrible thing. And I know you being in the system and handling a lot of cases, your personal feeling and gut feelings when somebody gets convicted to death. How do you feel on that?
I always say there's two answers. There's a constitutional answer and a personal answer.
Which is Frank's answer.
My personal answer is I'm against the death penalty. First, because I've been in the system for a long time, and I know the system gets it wrong sometimes.
Correct.
People say, yeah, how many times? It doesn't matter. It could be one time. It's one time too many. Second, personally, just for faith, and I just think that, whether somebody lives or not, it's a decision for somebody bigger than us.
Correct.
The guy upstairs. Yes. You didn't ask me for my other answer, but my constitutional answer, which I've read, I hope my death penalty clients don't get upset at me, but my constitutional answer is, do I agree that under the constitutional death sentence is legal? I kind of do. It's a very complicated answer. People give their opinions based on their personal opinion, but there's really the legal opinion is whether constitutionally it should be. So that's different. But personally, no, I'm against the death penalty. I think, first of all, a lot of people don't know this and don't take my word for it, because I haven't really done the research. But most people will tell you that the life sentence is cheaper. Death is cheaper than life, and I believe, I'm almost positive that that's a wrong answer. The death penalty, people sentenced to death penalty, cost the government. Not that cost should be even part of our conversation, but just so that you know, I believe it costs the government 4 times more than sentencing somebody to life. Even though that's, to me, that shouldn't be a factor. No, I'm not. I'm against the death penalty. I just think that is something for a higher person or being or a higher authority to decide.
Well, we actually...
I think that the life sentence accomplishes the same purpose. It gets you to the same place.
Well, we actually went to a Life Over Death conference, and I met you out there. You, because you need your certain credits. Myself, in order to be a mitigation specialist, you have to go to some of these conferences as well. And they had a couple people there that we met, and actually you knew one of them that was actually on death row, and one of them was found not guilty where he was taken off. And that's a perfect example of what you're saying, that it just takes one individual that's not guilty, and the system got it wrong. We certainly thank you for being on our show, and look forward to your many conversations we're going to have in the future. And I like to hear all your victory stories, because you have many. Gotham Investigations, Jeff Giordano. Stay tuned for our next episode. Are you a fan of our show? Do you like our show? Then comment, hit the like button, and subscribe, or you might be the next one we investigate.